If you were around in the 1990s, you may remember watching television on big cathode ray tubes such as the top-of-the-line Sony Trinitron. You might also remember TV commercials featuring Kool-Aid Man. Kool-Aid Man, an anthropomorphized giant pitcher of red sugar water, was featured in dozens of commercials bursting through walls while exclaiming,
"Oh yeah! Uh-oh!"
Such is the grace with which purported Nigerian President Bola Tinubu motioned to intervene in the FOIA lawsuit I had filed to obtain documents about his history of international money laundering. With his lawyers unsure of who they represented or what case they had even filed in, it was a bit like Kool-Aid Man crashing through the wall, by mistake, into a courtroom he wasn't sure he was supposed to be in, but also like Kool-Aid Man had a client who laundered money for a Chicago heroin ring in the early 1990s. If this sounds confusing, you should start watching with Part 1. Tinubu's local counsel, located in Washington, D.C., ultimately made use of the pro hac vice process to rope in 2 more lawyers. This kind of thing is common. Lawyers are required to be a member of a court's bar in order to practice there. Since the lawsuit was based in the United States District Court for the District of Columbia, Tinubu needed a lawyer in D.C. When a lawyer is not in the right place, he or she can effectively phone a friend and have them bring them in for that one case. Since Tinubu's go-to attorneys, who had just finished losing a court battle in the Northern District of Illinois involving his academic records from Chicago State University, were not based in D.C., they called Brian Carey. With its only 2 offices in Chicago and Boston, and no FOIA expertise to speak of, the law firm of Henderson Parks was a curious choice for representation in federal court in Washington for this type of case. Nonetheless, Henderson Parks quickly filed a motion to intervene on Tinubu's behalf, which was assigned Electronic Case File, or ECF, number 18 on the docket. In the motion, filed October 23rd, Tinubu's lawyers argued that their client, quote, has privacy interests in IRS and federal law enforcement records sought because those are records about intervener and contain private information. What they didn't seem to realize is that first, in the short term, there wasn't much to intervene over, since the government had already agreed to produce documents, and second, I had already had a telephone call with a lawyer for the IRS on October 6th, and the day before that call, in preparation, she had sent me an unsigned declaration by another IRS lawyer explaining that to the best of the agency's knowledge, the IRS had destroyed all of its files related to the case. This was actually plausible. The Washington Post recently wrote a long profile about the myriad problems at the IRS, which, thanks to persistent Republican Party worship of tax evasion, general intransigence, and abject stupidity, has been strangled for decades, forcing it to rely on ceaseless tons of paper, millions of staples, and mainframe computer technology from the 1960s. It is reasonable to think that in such an environment, having a strictly enforced document destruction policy might actually be pretty important. Still, it was odd that the declaration was not signed, and that neither the IRS lawyer nor the Assistant United States Attorney, or AUSA, assigned to the case, Jared Littman, were willing to file it on the docket, where the court, and later Tinubu's lawyers, could see it. So I filed it for them. In response to Tinubu's motion to intervene, I included a copy of the unsigned IRS declaration and the email it arrived in as an attachment, and generally opposed the notion that Tinubu had any need to intervene in the case, given that the IRS was now arguing that it had made an error when it previously stated that the documents were considered tax information. The IRS now said that, in fact, because the documents were compiled under Title 18 of the United States Code, which is the criminal code, the documents would have been accessible via FOIA had they not been destroyed. Judge Beryl Howell ultimately granted Tinubu's motion on November 27, 2023, but it was a Pyrrhic victory for him. Since FOIA document production had long since begun, his being involved in the case as an intervener had no real impact right away. More on those documents in a moment. And since Judge Howell did not grant his motion until over a month after it was filed, Tinubu may have felt in the interim that he needed a backup plan. Although the U.S. government was quite clear that documents would be released starting at the end of October, no one was sure what would be in them, putting Tinubu under considerable pressure to cement his legitimacy as president before then. The fact that he had even considered intervening in the FOIA case suggested that he was deeply afraid of what might be revealed, and so he likely asked some of his friends for a favor.
Begin in Abuja, where the Supreme Court has reserved judgment in the appeal filed by the People's Democratic Party, challenging the judgment of the Court of Appeal, which affirmed the victory of Bola Tinubu at the presidential election.
Suddenly, there was a race between courts on opposite sides of the Atlantic, and Tinubu had the advantage. A FOIA lawsuit is basically a streamlined civil lawsuit. While a civil lawsuit can ask for all kinds of relief, the point of a FOIA lawsuit is simply to obtain documents. That makes the typical discovery process, where each side provides documents to the other, redundant. Judges expect the government to provide any documents it's willing to offer in parallel with the litigation outside of court, and to provide regular status updates in court on how that process is going. This makes the Periodic Joint Status Report, or JSR, the heartbeat of FOIA litigation. It's joint because all of the parties are supposed to work together to inform the court as to what's happening. Sometimes, when parties can't agree, the report gets broken into separate sections for the plaintiffs and defendants. And sometimes, judges get annoyed when there appears to be too much disagreement, so there's an incentive to work together. Usually, once all of the documents have been turned over, the case proceeds to summary judgment, where the parties battle over any remaining legal issues concerning whether or not the government revealed everything it was obligated to under the law. It was in the first joint status report that the government defendants stated they were willing to provide documents by the, quote, end of October. Since this was already a major improvement relative to their prior stance, which was that they produced no documents at all due to the lack of interest by the American public and Tinubu's personal privacy, it seemed unwise to push for an exact date. I did ask via email, however, that the government not sit on documents for no reason, which is something that often happens. Then, on October 19th, after Tinubu's lawyers made his intention to intervene clear, but before they filed the actual motion, and with the end of October approaching, the Supreme Court of Nigeria decided to accelerate the hearing date for a set of Nigerian petitions challenging the legitimacy of Tinubu's election, brought by some of the other candidates, including Atiku Abubakar and Peter Obi.
The seven-justice panel is led by Justice Inyang Okoro, who had earlier told parties that judgment in their appeal will be reserved. While the Allied People's Movement also withdrew its appeal challenging the election of Bola Tinubu, the Supreme Court also reserved judgment in the appeal filed by the Labour Party and its candidate, Peter Obi. In attendance during Monday's proceedings were the All Progressives Congress National Chairman, Abdullahi Ganduje, as well as Chairman of the Labour Party, Julius Abure, the Chief of Staff to the President, Femi Gbajabiamila, the National Security Advisor, Nuru Ribadu, and other party faithful were also in attendance. Atiku Abubakar is seeking to bring in fresh evidence to prove his disqualification appeal against President Bola Tinubu.
As David Hundeyin explains, even though the world seems to have moved on, the election was anything but free and fair.
No one has been able to prove that there's any evidence whatsoever that the result that was announced had anything to do with the actual turnout, with the actual verdict of the people that was delivered at the polls on February 25. It just so happens that this is someone who has essentially demonstrated that it's possible for one person, for one small group of people, to overpower an entire country of 210 million people, provided they have sufficient resources and sufficient international support, i.e. the U.S. government.
The Nigerian appellate court's decision on these petitions to re-examine the election, and Tinubu's legitimacy as a candidate in the first place given his criminal past, was an 800-page, 250-megabyte scanned document lacking optical character recognition, making it difficult to read, let alone understand. When I started digging through it, however, it contained a number of interesting details that seemingly escaped everyone's notice, including Nigeria's Supreme Court justices. Ironically, through his lawyers at Henderson Parks, these documents were volunteered up to the federal court in the Northern District of Illinois by Tinubu himself, as ECF number 34 in Abubakar v. Chicago State University. The Nigerian petitions largely centered on the question of whether Tinubu had a criminal record in the United States. Yet the arguments on Tinubu's behalf stopped well short of a blanket denial. On page 134, Tinubu's lawyers were cited by the court, noting that the National Crime Investigation Center, or NCIC, stores, quote, records of every criminal arrest and conviction within the United States of America, but omitting any mention of the possibility that Tinubu was indicted without ever being convicted, which would not necessarily appear in the NCIC database. An indictment is not a, quote, arrest, warrant, or warrant. This makes the February 4, 2003 letter from Michael H. Bonner, which Tinubu's lawyers also cited using Bonner's incorrect middle initial, largely irrelevant. The Bonner letter is intriguing for a different reason, however. It states that the NCIC database was searched on Tinubu's name with the date of birth of March 29, 1952. But that's not Tinubu's actual birthday, or at least it's not what Tinubu said it was when he lived in the United States in the 1970s. If Tinubu was indicted or arrested, his date of birth in the FBI's database is almost certainly not March 29, 1952. Tinubu may have very well been instructed to forget his birthday if he wanted to pursue a career as a politician because of the potential problems it could cause for him as someone with a criminal past. As a result, regardless of whether it's relevant, the Bonner letter about the FBI's records cannot be relied upon, just like the FBI's supposed determination that Tinubu never attended Chicago State University was incorrect because his name was misspelled with an O instead of a U. On page 182, the appellate documents again cite lawyers and so-called witnesses for Tinubu arguing that he was not criminally charged and has no criminal record in the civil forfeiture case. This makes sense. It's impossible to be criminally charged in a civil case. This is kind of like asking someone, did you steal the cookies? And getting back the answer, not from the produce section of the grocery store. Of course not. That's not where you'd find them, but it certainly does not rule out the person stealing the cookies. Being overly specific to evade responding to a question one would rather not answer honestly is a lawyer's trick as old as the profession itself. As an aside, part of what helped Tinubu's lawyers get away with this is the particular style in which they wrote the case number, 93C4483. The formal case number in PACER for the Tinubu civil forfeiture matter is 193CV04483, with the CV making clear that this is a civil case. A criminal case would say CR. Finally, on page 184, one of Tinubu's lawyers told a flat-out lie, which is that, quote, if someone has a criminal record, the general record will show it. This is simply false. The United States Department of Justice routinely seals criminal cases for a variety of reasons, and when that takes place, it's not apparent to anyone that the defendant has a criminal record, until the case is unsealed. This could take days, weeks, months, years, or never happen at all, depending on the circumstances of the case. Having criminal records sealed is so common in the United States that lawyers make advertisements on YouTube encouraging prospective clients to hire them for help with the process. Here's an example of just one from Illinois.
Well, obviously having any sort of criminal conviction or even an arrest on your record can be very detrimental to your future opportunities, finding a job, getting into a school, things of that nature. So when we undertake the sealing or expungement, that basically makes that record invisible, or actually it may also make it cease to exist depending on what we're able to achieve through the course of it.
Combined, all of these evasion tactics leave the distinct impression that the Supreme Court's decision was fundamentally flawed in multiple respects, that Tinubu has been trying to talk around the possibility that he was indicted in the United States for a variety of crimes stemming from money laundering on behalf of Muiz Adegboyega Akande and Abiodun Agbele, and that his indictment remains under seal pursuant to a cooperation agreement with federal authorities. If this is correct, the Nigerians would have wound up with a foreign asset as their president, much as Americans elected a Russian asset as their own president in 2016. The matter of the 2023 election petitions was supposed to be taken up by the Supreme Court of Nigeria in early November, but instead of holding the hearing in early November, on Friday, October 20th, I learned that it was suddenly scheduled to be held the next business day, Monday, October 23rd, 2023. In the United States, where due process is built into the Constitution, this kind of abrupt schedule change would be unthinkable in anything but a capital punishment case. It seemed highly unlikely that the court in D.C. would be able to do anything about it, but I decided to make the judge aware of the situation and via an emergency motion, ECF number 17, requested a hearing on the 23rd to at least discuss the issues surrounding the sudden changes by the Supreme Court of Nigeria. In theory, documents the U.S. government was sitting on could have made a difference in the Nigerian case, and that could have been a very big deal for Nigerian democracy. The U.S. government had, after all, already promised to begin producing documents at the, quote, end of October. Even if nothing could be done before the Nigerian case hearing, it was still possible that the American court might issue a ruling holding the U.S. government to its word before the Nigerian judgment issued affirming Tinubu's election. It was worth a shot. Sadly, on October 23rd, after the hearing had already taken place in Nigeria, Judge Howell issued a ruling denying the emergency motion. She interpreted it not as a request for a hearing, but as a request for an injunction, which meant that the request had to meet stringent requirements I hadn't bothered addressing given the short time frame, and because I wasn't asking for a formal injunction. I just wanted the government to produce the records it had already compiled at this stage of the end of October, something some judges might have addressed through a simple, relatively informal, 1 or 2 sentence court order. Here, again, an email from the United States Department of Justice AUSA that the court was not privy to had informed my thinking. On September 12, 2023, a day after that first JSR was filed, AUSA Jared Littman sent me an email in response to my request stating, quote, "I will advise the agencies that, should their productions be ready before the agreed-upon anticipated dates set forth in the Joint Status Report, they should not wait, and they should produce as early as possible." Now that promise actually mattered. Unfortunately, the judge didn't seem to think so. But her ruling had more than a few minor errors in it, and her interpretation of my basic request for a hearing as a request for an injunction, and specifically a temporary restraining order, seemed overly formalistic. By this point, it was clear that Judge Howell was annoyed, but the race against the end of October wasn't done. On October 25th, the Supreme Court of Nigeria then announced that it was also moving up the date of judgment on the election case to the 26th, the very next day. There was simply no way that any American court could keep up with this absurd judicial ping-pong match as Tinubu and his allies tried to front-run the disclosures. I filed a request for judicial notice, ECF number 23, informing the U.S. court of the latest change, just to have it in the record, and also included articles about Tinubu's relationship with the Nigerian Supreme Court's Chief Justice, whose son earned himself a judgeship of his own in Nigeria upon Tinubu's election. On the 26th, surprising no one, Tinubu's Supreme Court confirmed the supposed legitimacy of his election. That led to this self-parodying video of Tinubu celebrating at his desk at the Aso presidential villa in Abuja with his groveling lieutenants, joking with several in turn, "Your job is secure."
Thank you, sir. Congratulations, Your Excellency. Your job is secured. Spoke to. Your job is secured. Congratulations, Your Excellency.
There is no conclusive evidence that Tinubu himself was behind the Nigerian Supreme Court's machinations. However, the timing is highly suspicious, and Tinubu was clearly aware of the FOIA lawsuit, given that he is on the record as having made preparations to intervene just before his Supreme Court began changing its schedule. It's hard to imagine any other reason for the Nigerian Supreme Court's massively accelerated calendar in the election case. In a way, not having to play catch-up with the fastest court in the world was a relief. Now the lawsuit could go on like any other normal FOIA lawsuit, slowly. 6 months after filing the initial complaint, the government had produced about 650 pages of records, while carefully redacting Bola Tinubu's name from all of them, or withholding pages entirely. Some of these records were mundane, like pages describing how the FBI requisitioned the purchase of an IBM PC for the investigation, and others quite interesting. The goal was still to figure out the details of what IRS Special Agent Kevin Moss's affidavit left out. Why, despite committing at least 6 federal crimes described in detail, Tinubu was never criminally charged. As David Hundayin explains, the lack of public criminal charges has introduced an element of plausible deniability for Tinubu, even though the details are there in black and white.
There is this perception across a large segment of the Nigerian audience that it's the story is probably true because David Hundayin reported it. And I'm like, you don't need to believe that something is true because I reported it. The evidence is there. Go read it for yourself. But it's like, yeah, okay, we see the document and we've read what is inside. But if this thing is true on its own merit, then how come XYZ hasn't taken place? So there's this sort of almost like people can see that 2 + 2 is clearly 4, but because the institutions that are supposed to act on the fact that 2 + 2 is 4 haven't acted, therefore that means that maybe there's something else. There's some missing context, or maybe this is all some kind of mistake, or So very often it has then turned out to be the case that I have become the story. So it's become almost a case of this one journalist trying to take down this politician, and that's not the issue at all. It's not about me trying to take down Bola Tinubu, man to man. That has nothing to do with it. This is an issue of the basic sanctity or the basic integrity of the electoral process in Africa's largest democracy, or what purports to be Africa's largest democracy, that a country of 200+ million people really shouldn't be having a drug trafficker on its ballots.
Even though additional documentation is not strictly necessary to determine that Tinubu engaged in criminal activity, the heavily redacted FOIA documents were nonetheless bringing some additional clues into focus. First, some of the documents came from places no one was expecting: Brussels, Belgium, London, Hong Kong. The joint FBI-DEA-IRS investigation into a relatively tiny narcotics distribution ring in the small city of Gary, Indiana, was actually enormous, spanning the entire globe. Second, the documents made reference to a cooperating witness, or CW, something that had also been mentioned in the Moss affidavit. Third, the FBI files provided some insight into the evolution of the way the Bureau treated the case internally as it got bigger and bigger, something that required repeated modifications to the case number. Fourth, there was a fugitive that the FBI was trying to track down. Overall, the FBI and DEA devoted substantial resources to monitoring the Edwards ring in person, through Title III wiretaps of telephone lines, and by even digging through the trash. As of 1990, the FBI believed that the Edwards ring was earning between $15,000 and $20,000 per day from sales of, quote, multiple kilos of white heroin each month. And although much was redacted from the files, the FBI left unredacted references to Moise Adegboyega Akande, because according to the Department of Justice, Akande was dead. That meant that under the law, he was no longer entitled to privacy. As a result, some of the FBI's remarks about Edwards' source shone through, quote, a Nigerian drug trafficking group possibly headed by subject Adegboyega Akande, based in Chicago. It's worth noting that upon Tinubu's death, his privacy rights under United States law will also die with him. Any objective observer examining all of the available evidence would reach the conclusion that Bola Tinubu is a scared man with more than a few secrets, a man with a history of lying under oath, and a man dependent upon an obviously flawed and corrupt judicial process in his home country to cling to power. The only thing preventing the public from learning the full story would seem to be the U.S. government's unusual refusal to confirm or deny Tinubu's involvement in the story already detailed in the IRS affidavit from 1993. But that could change, because Glomar responses don't always hold up in court. Rather than wait for the judicial process, however, I decided to visit the Chicago branch of the National Archives. FOIA isn't the only way to discover information about what happened 30 years ago, and that's where I made a key discovery. To learn what happened next, check out Part 3, or to view any of the files mentioned in this video, go to plainsight.org.